on the road for the case for accused number 6. May I propose the message?
Right, the applicants may remain seated. Advocate Wilkins for applicant number 5. You closed his case yesterday.
Indeed, Sir, Your Worship. Thank you.
Thank you. Mr. Van Haas.
May it please the Honourable Court, Your Worship, I yet again confirm my appearance on behalf of applicant number 6. We've elected to present our evidence by means of affidavit. If I may hand up the original statement to the Honourable Court. I've also provided the statement with a copy as well.
Thank you.
If I may proceed, Your Worship.
Proceed, sir.
Thank you, Your Worship. I, the undersigned, Jean-Marie Extian, an adult female residing at number 13 Clapper Street, Van Dyke Park, Boksburg, do hereby state as follows under oath. I confirm that the information within this statement is a true and accurate representation of the facts. Introduction. I am applicant number 6 in this case and was advised that I face charges of murder, robbery with aggravating circumstances and defeating or obstructing the ends of justice. I was further advised that the bail application fall within the ambit of Schedule 6 of the Criminal Procedure Act 51 of 1977. I am therefore shouldered with a burden to prove that exceptional circumstances exist which, in the interest of justice, permit my release on bail. I was further advised that I am entitled to apply for bail by adducing evidence orally, or I can submit my evidence by means of an affidavit. Considering the number of applicants in this case, I was advised that an application by means of an affidavit will expedite the proceedings, and my decision in this regard should be regarded as practical rather than to avoid cross-examination by the state. Personal circumstances. I reside at the above-mentioned address for the past 27 years. The property was transferred from my mother, Adele Extian, in 2026 to me. The house is fully paid for. My mother and my 3 minor children reside with me at the premises. See attached annexes JE1 and JE2. I'm a 33-year-old female and am employed on a temporary basis in Dubai as personal security. I simply had to find a source of income to support my children. I was employed by the South African Police Services for 16 years, but my services were terminated due to the allegations against me in this case. I'm in the process of appealing the decision in the disciplinary hearing. I'm a South African citizen. My identification number is 920921003388. A copy of my identification document is attached here to as Annex JE3. I'm single and I have 3 minor children. For obvious reasons, Your Worship, I'm not going to read the names of these children into the record, if the Honourable Court will allow me. I was informed by my attorney that I am compelled by law to reveal to the Honourable Court any outstanding cases and or previous convictions I might have. I've also been informed that failure to do so may result in criminal prosecution and a sentence not exceeding 2 years imprisonment or a fine. I have no pending cases against me and have no previous convictions. I'm not on parole on any case. I've never had a protection order from domestic violence or harassment by the deceased against me. Interest of justice as envisaged in 60 subsection 4 of Act 51 of 1977. I was advised that the interest of justice does not permit my release on bail if one or more of the grounds in this subsection is established. It is therefore deemed prudent to canvass these grounds in this statement. Whether is the likelihood that the applicant will endanger the safety of the public or any person or commit a Schedule 1 offence. It is evident from my clean record that I do not have a propensity to commit crime. I am aware that should I be arrested on another Schedule 1 offence, my chances of getting bail are almost non-existent. There is no evidence to suggest that I was involved in the demise of any of the potential state witnesses in this matter. possibility that I shall not stand my trial. I was first notified about the charges against me in 2023. I was requested to submit a warning statement, which I did. My exculpatory statement forms part of the case docket. Subsequently, I only heard the testimony of Van der Merwe in the Madlanka Commission in November 2025. I was shocked to hear the averments made by witness Van der Merwe regarding my alleged involvement in the crimes. Despite these allegations, I never made any attempt to evade my prosecution. In March 2026, the SAPS commenced disciplinary proceedings against me, which resulted in my dismissal on 7 April 2026. I attended my disciplinary hearing as instructed to until my dismissal. After my dismissal, I tried to obtain alternative employment. I managed to get temporary employment in Dubai, rendering services as personal security. On Monday, 6 August 2026, the investigating officer from IPIT, Ms. Masuku, arrived at my house to arrest me. My mother called me to advise me of Ms. Masuku's visit at my residence. I then sent a WhatsApp to Ms. Masuku and requested her to provide me with a copy of the J50 warrant of arrest. Ms. Masuku sent me a copy of the J50 warrant of arrest, which I attached here to as Annexure JE4. I advised her that I shall return to South Africa. I then made arrangements to travel to South Africa and arrived at Oliver Tambo International Airport on Monday, 10 August 2026. Upon my arrival, I immediately consulted with my attorney. On 11 August 2026, I contacted Ms. Masuku to advise her that I am back in South Africa and made arrangements to surrender to her on Wednesday, 12 August 2026 at 15:30 at Brakpan Police Station. Ms. Masuku fell ill and I was told to report to Brakpan Police Station on Thursday, 13 August 2026 at 0800 hours, when I was arrested and taken to court. I had ample time to evade my arrest should I have any intention to do so. I'm willing to abide by any terms and conditions of bail imposed upon me by the Honourable Court should bail be granted. I cannot afford to forfeit any money should bail be granted. I do have a passport and use same to travel for work. I shall, however, surrender my passport should the Honourable Court so instruct. I have no family or assets outside the Republic of South Africa. I have one property registered to my name with particulars mentioned above. I do have a City Golf Model 2014 valued at plus minus 50,000 Rand. I also have furniture valued at plus minus 200,000 Rand. I was born in Germiston and have been staying in the East Rand all my life. I finished matric at Hoërskool Oosterlug in Boksburg in 2010. My father is deceased. My mother resides with me. I have one brother, Deerwald, who stays on the East Rand as well. The state's allegation that I pose a flight risk is unfounded and indeed preposterous. Influencing or intimidation of witnesses or destroying or hiding of exhibits. I shall not interfere with any state witnesses, neither have I interfered with any state witness until now. It is ludicrous to suggest that I should not be granted bail on this ground. I am not in possession of any exhibits and my release on bail will not jeopardize the investigation in any way. The offence was committed in 2022 and I find it hard to fathom how I shall interfere with state witnesses only now. I am aware that should I have any contact with any of the state witnesses, my bail will be cancelled and my bail money be forfeited to the state. I fail to understand how I can interfere with the investigation of the case after 4 years have lapsed since the commission of the offence. Undermining the system of criminal justice and bail, there is no indication that I shall not comply with any bail condition. I shall give my cooperation via my legal representative if anything is required of me by the investigating officer. I was advised that I am presumed innocent until proven guilty. That my release on bail will disturb the public order, public peace, or will undermine the security thereof. I verily believe that the community will not condemn my release on bail, therefore it will not disturb the public order or undermine public peace or security. There is no indication that my own safety will be jeopardized should I be released on bail. Prejudice towards myself and my family if bail is denied. I've been informed that the court rolls are congested and that might lead to incarceration for a long period of time. Should I be incarcerated, I shall not be able to generate an income to maintain my children and to generate money for legal services for my trial. At merits, I vehemently deny the allegations against me and intend to plead not guilty to the charges preferred against me. I was furnished with a copy of the case docket to prepare for my disciplinary hearing. Having perused the statements contained in the case docket, I submit that the state's case against me is weak. The only evidence that implicates me in these offences is the hearsay evidence of the late witness van der Merwe. The latter's evidence is of a contradicting nature and will be severely challenged during the trial. I was summoned to the scene on the night of the incident and was involved in the search of the outside rooms of the premises. When I left the scene, nobody was injured that I know of. I deny that I assaulted anyone or was involved in any robbery. I deny that I was involved in the killing of the deceased, the disposal of his body, or that I even knew about these acts. Amount bail. I do have money for bail. I shall be able to pay an amount of 5,000 rand for this purpose. My friends and family will assist me if the Honourable Court deems it prudent to fix a higher amount bail. Conclusion. Bearing in mind the facts set out in this statement, I submit that exceptional circumstances exist which, in the interest of justice, permit my release on bail. The statement was then duly signed by the deponent, Your Worship, and I would like to, and it was disclosed to you as well. May I hand it, or may it be then accepted formally as an exhibit on behalf of the applicant number 6.
Yeah. Before that, Mr. Van As, 2.3. I am 53-year-old female and I'm employed on a temporary basis in Dubai. For record purposes, where is this Dubai?
Where in Dubai?
Where is Dubai for record purposes?
Dubai purpose is in the United Arab Emirates, Your Worship.
Okay. And then 5.2.15. I do have a passport and use same to travel for work. I shall, however, surrender my passport should the Honourable Court so instruct.
Indeed, so, Your Worship.
Does she intend to go back and work in Dubai, Mr. Abbas?
Your Worship, if there is a possibility that the Honourable Court will allow her to leave the country, that was the place where she was able to obtain employment at the stage. However, if the court is of the view that it would sustain a flight risk, obviously my client is prepared to hand in the passport as well.
Thank you. I hear you. Ma'am Extian, please stand up. Do you confirm the contents of this affidavit?
I do, Your Worship.
This is marked Exhibit F.
As it pleases the Honourable Court, Your Worship, that is the case for the applicant number 6.
Thank you. Advocate Taiwo.
There's been, in opening our case, there's been a change of plan from Mr. that we wanted to only submit the after the employment, and then on to meet the different authorities. Then after everything covered the supervision on the affidavit by my friends and then through of their clients. We obviously everything that affidavit will address everything that is in those affidavits. So I don't need to call the revision officer. I will just submit the affidavit of the IO and then close my case. So can I start with the just that?
So, in other words, you submit that the investigating officer is available should the court decide to call him.
Yes, sir.
Absolutely. Then you may proceed.
Thank you, sir. Worship, I have prepared a copy of the affidavit. This is the original one. May I approach the person? And then my friends, I've also made some copies for them, Worship. They are inside. Can you share them, sir? I think it is in paragraph where the definition of the worship is on page 7. I think it's paragraph 1, the third paragraph there. From the top, it starts with the word the extent. There is at the last words of that paragraph say that Mr. Sorting affidavit. Basically, is the cost of that of the affidavit that is going to be the attachment to this affidavit. May I ask the question then? My dear friends, may I start?
Yes, proceed, sir.
It reads as follows. In the Magistrate Court for the District of Ekurhuleni, held at Brakpan, this case number A604-2026, in the matter between Brakpan, Robert Esmande at the Norman Mackenzie, Specialty Stores, Julius Mkhwanazi, and John Murray Estate, and the state as the exponent. This is the affidavit in terms of section 6711. A of the Composer Act of 1977. Non-subsidiary Masuku speak under oath in English that, paragraph 1, I am holding a position of a senior investigator with the service number, which is my annotated at the number, employed by the Independent Police Investigative Directorate, known as IPID, situated at Bromfisher Towers, 20 Albert Street in Johannesburg, which product numbers indicates 01002774118. I am investigating a murder case as per Brakpan CAS 42904-2022. Paragraph 2. I am the executing officer of the matter. In the matter, as a step under Brakpan CAS 42904-2022, involving the murder of the late Emmanuel Mdenze. Paragraph 3. The first contents herein are, unless otherwise indicated, within my personal knowledge and are both true and correct. Where I rely on information received from witnesses or the documental evidence, I believe such information to be true. The background of the offense, that is now the start of paragraph 4. On the 14th April 2022, at approximately 9 in the evening, that is 21 hours, the deceased Emmanuel Mdenze was at his residence situated at Crocodile Street, Salis Village, Brakpan. Paragraph 5. A group consisting of members of the Southern Police Services, that is the SABC, members of the Ekurhuleni Metropolitan Police Department, that is AMPD, and private security personnel arrived at the residence while conducting what they allege to be a raid in connection with property reported stolen on 9 March 2022 at Raider Electric Warehouse, where security guards from 24/7 security were robbed at gunpoint by a number of gunmen. The robbers used to 2 trucks and a battery to load a large amount of copper from the warehouse. Case was opened under because of North 14203-2032. Paragraph 6. It is alleged that the deceased was assaulted and tortured by members of the group in an attempt to compel him to disclose the whereabouts of the allegedly stolen property. The assault continued for a long time until the deceased stopped fighting and blocking the blows. Paragraph 7. On the 15th April 2022, at approximately 14:45, the body of the deceased was discovered at Spar Vater Dam in Julius. A postmortem examination was conducted, which concluded that the cause of death was head injury due to blunt force trauma, consistent with a severe assault inflicted upon the deceased. Persons present, that is now paragraph 8. Investigation established that the following individuals were present during the raid at the deceased residence. Such members were the Gopa Kesbande, Juan Mariestin, Alexander Fritz, Mzwake Koza. EMPD members were Adrian Norman Mackenzie, Keisha Lee Stolz. Private security personnel were Etienne van der Waalt, Vian Pretorius, Jaco Hannekom, Kopas van Rensbeck, and Marias van der Tornebe. Evidence obtained during the investigations, that is now the chapter paragraph 9. Approximately 5 months after the incident, Marias van der Merwe voluntarily approached law enforcement authorities and made a detailed statement regarding the events of the 14th of April 2022. He stated that the deceased had been assaulted, and when he was no longer defending the blows from the torture and not moving anymore, the group decided to conduct Julius Mkhwanazi, then head of EMPD. According to his statement, upon his arrival, Julius Mkhwanazi was briefed by Pretorius that Chief is that time again. Julius then instructed that the seaboat be removed and disposed of immediately by dumping it into the spar Vater Dam. Marius further stated that while the seaboat was being loaded into the vehicle he was riding, several members removed property from the deceased residence and loaded it into their own vehicles in the full view of other members. After disposing, that is after disposing of the body, a meeting was allegedly held near Carnival City, during which all participants were instructed to keep the incident secret and were threatened death should they disclose what had occurred. It was at that meeting where Exastros advised everyone to avoid talking about this incident on cell phones. Another meeting was held on the following day, that is the 16th April 2022, at Rose Tree, where the members voiced their concern that they did not trust that Marius, Diago, and Cobas would keep this secret. Again, they were threatened with being killed if they tell anyone. Paragraph 13. During the subsequent investigation, Etienne van der Waalt also came forward and made a statement. His version corroborates in material respect the account previously provided by Marius van der Merwe regarding the assault, the concealment of the deceased body, and the events following the matter. Subsequent events, that is now paragraph 14. The investigations has revealed an alarming sequence of death involving persons connected to this matter. 14.1. Ekurhuleni was later shot and killed on 17 March 2023. 14.2. Mzwake Koza was subsequently shot and killed on 17 October 2025. 14.3. Marius van der Merwe, after giving evidence before the Madanga Commission of Inquiry, was murdered by assailants armed with an AK-47 on the 5th of December 2025. The other Victorious later died after allegedly taking his own life. This incident demonstrates a disturbing pattern affecting individuals connected with this investigation. Paragraph 15. grounds for opposing the in terms of section 60, section 4. 15.1, section 64A, likelihood of endangering the safety of the public or committing a Schedule 1 offense. The accused is charged, they are charged with an extremely serious offense involving the alleged torture, murder, and the disposal of the excess body. The offense demonstrates a high degree of violence and it is a regard for human life. The investigation further revealed allegations of organized conduct involving multiple individuals acting together. The release of the accused poses a real risk to the safety of the witnesses and members of the public. It is well known that most security companies in Gauteng province make their profit from demanding 10% of the value of the recovered stolen stock emanating mostly from hijacked cars. Therefore, it was unbelievable why such a big armed contingent of security cluster members converged into the deceased home and tortured him to death. 15.2, 664B, to evade trial. The seriousness of the offense and the severe sentence, which is life imprisonment, that may follow upon conviction, provide a strong incentive for the accused to evade trial. Given the gravity of the allegations, there exists a substantial risk that the accused may have scorned if released on bail. 4C, likelihood, that is the likelihood of influencing or mitigating the witnesses or concealing or destroying the evidence. The state intend relying on several witnesses, including individuals who were present during the incident. Evidence gathered during the investigations indicate that participants were allegedly threatened with death should they disclose what had occurred. Several persons connected to the matter have subsequently died under violent circumstances. The death of Yabo, Hanekom, Zwake, Koza, and Marius Paranebe, together with the death of Leandra Pretorius, create legitimate concern regarding the safety of the remaining witnesses. One of the witnesses, that is now Etienne, previously received death threats and he was in a secret location for a period of time. The extent of the threatening situation in which Marius found himself in was laid bare in the recent bail application of Mr. Soteni, who is accused of killing him. He told the Brakpan court that Julius approached him about the Marius more than once after he testified in the Matanga Commission. He said that he was driving with Pretorius on the day the deceased was shot, after Pretorius was brought to him by his wife. But he was 2 streets away from his place, that is Mr. Soteni's application. Should the accused be released on bail, there is a likelihood that witnesses may be intimidated, influenced, or harmed, thereby jeopardizing the proper administration of justice. There is evidence that one of the accused persons have a negative influence on other accused persons. This is according to Etienne, who said that Mkhwanazi was supervising them when they were giving warning statement to IP officials. He said how the content of the administrative statement should look like. This coaching in communication is visible in the Mr. Stone's, that is his broadcast 27903 of the 23 case, and in the warning statement they gave in this current case. They are unbelievable in the same sequence. 15.4, section 64D, likelihood of undermining or jeopardizing the objective of proper functioning of the criminal justice system. The allegation involved members of law enforcement agencies acting together with private security personnel. The investigation revealed allegations of assault, murder, concealment of the body, removal of property from the deceased resident, and a subsequent attempt to conceal the commission of the offense. The release of the accused would undermine public confidence in the criminal justice system and may interfere with the ongoing investigations. Section 64E, that is paragraph 15.5, exceptional sentences disturbing the public order or undermining public peace or security. The matter has affected a considerable public interest because it concerns allegation of serious misconduct committed by individuals entrusted with enforcing the law. The alleged murder of the body, concealment of the evidence, and subsequent death of witnesses have heightened public concern. The release of the accused is likely to undermine public confidence in the administration of justice and may disturb the public order and security. Conclusion, that is paragraph 16. In regard to the seriousness of the offense, the strength of the case, the existence of corroborating witness evidence, the alleged threat made to the participants, the subsequent death of several persons connected to the investigation, the real risk of witness intimidation, the possibility of interference with the investigation, and the interest of justice. I respectfully submit that the interest of justice do not permit the release of the accused on bail. I therefore pray that bail be refused in terms of section 64 A, B, C, D, and E of the Criminal Act 1977. Paragraph 17. The binding effect and enforceability of bail conditions. The bail conditions are normally given to mitigate the likelihood of interference with witnesses and in respect of likelihood that the accused will evade his or her trial. In this case, the likelihood is the killing of witnesses, which is explained already. It is one thing to give conditions that the accused should not harm or kill witnesses, but to enforce is almost impossible. In this case, the key witnesses are the accomplished witnesses, and the accused know that fact. Death of this remaining witness will compromise the case. This language by Ms. Masubi. I would just, I'm not going to leave the word of the one of that attachment. I will just go straight to where I would like to read for the record that part. Because it's a thick document, so I'm going to just zoom to, it's not number, but just after paragraph 10, that is the second absences. Oh, let me go straight. Okay, so there is after it, this sustaining the binding the page. Oh, sorry, let me have. I can just go straight and open it. Paragraph 10, because it is not number this. Let me take through my little friends to also to understand where I'll be reading from. There's a page that says exceptional circumstances. Is paragraph 10, is marked as 10. And then the following page, it has one word expressed that in the precedence, the reserved security designation. Now I'm gonna start with the paragraph to read.
Yeah, I do not know whether the legal representative found the page.
I confirm that I have found the page, Your Worship.
Yeah, on top there is a word resign, handwritten. Mr. Sneeman, have you found it? Mr. Van As?
Thank you.
Mr. Van Heerden?
Mr. Van As assisted me. Thank you, Worship.
Ma'am?
I have found same, Your Worship.
Similar, Your Worship.
Thank you.
Thank you.
Proceed reading.
Thank you. Let me put the paragraph start with during. During the time where I was working for Mr. Said family, I met with Leandra Pretorius in Ekurhuleni, where he had arrested a truck full of illicit cigarettes. Myself and Leandra exchanged numbers, and the interaction happened around between 2019 and 2022. Leandra would, time to time, comment on my WhatsApp statuses and sometimes communicate with me telephonically. I would put status while at shooting range, and he would ask me to train him to be a sharpshooter, and he regarded me as his role model when it comes to shooting. Around November 2025, I was informed that Julius Mkhwanazi had been mentioned on the Madanga Commission, and his name has been trending on national TV as stated by the person identified as Witness T. I then checked on my TV, and indeed I heard Leandra's name being discussed. I was shocked, and I contacted Leandra to ask what is going on. During our telephone conversation, Leandra did not give full details about what transpired, and requested to meet with me. I told Leandra that I am staying at Glen, and we would meet at Glen Mall. After a few days, myself and Leandra met at Glen Mall parking next to the banking center, and he came driving white Isuzu taxi. I did not take down his receipt number. Leandra started to relate a story to me that in 2022, there was an operation where he was with such members, EMPD officials, and public security personnel on that particular operation. There was a male person who died and later dumped into a drain. Leandra further informed me that the body of that person was transported from the scene to the dam in a buggy. He also mentioned that EMPD Police Captain Brigadier Mkhwanazi was also at the scene where the male person was also at the crime scene where the main person did later dump into the dam. I could see that.
Just a moment, Council.
Oh, okay.
There is the word handwriting bed. Yes.
Yeah, that's at the crime scene where the main person did later get dumped into the dam. Yes. I could see that Leandra was in a lot of stress and seemed to be frustrated by his name being sent for wrong reasons. I think Leandra looked up to me and he respected me a lot, hence he confided on me. Leandra also wanted me to take him to the shooting range for training, but it never happened. After the meeting, we went our separate ways. Few days after the meeting, Leandra called me to come to Carnival City, and we met at the filling station next to Carnival City. I vividly remember this day, as it was on the 9th of November 2025. This is the day that I also purchased ammunition at Dave Share Guns in Bramley, where I normally purchase my ammunition for shooting range practice. I was driving a black Suzuki Swift with the number MP36FSCP, which belonged to my girlfriend known as Julius Mkhwanazi, whom I currently stay with at number 6 Beverly Hills, Unit 10, Basonia. At the Carnival City meeting, Leandra was continuing to explain his possession, and he also showed me pictures of a Zamazama guy who was buried alive, alleged by Madas Vandeneve, that is the university. I have picked up that there was serious animosity between Leandra and Marias. Leandra even told me that he has assaulted Marias as they were no longer in good relationship from Carnival City. We followed each other to Brakpan area. I was driving in a place to Swift registration number as I mentioned. When we got to Brakpan, Leandra stopped at the car wash, left the vehicle there and jumped into my vehicle, and we drove around. Leandra was the one driving in my Suzuki Swift, and I seated on the passenger. We drove around while talking about all his stories, asking me if I knew anyone who could help him with his problem. Leandra never specified this kind of help that he needed, but I could tell that he wanted Marias Father Julius killed. After driving around, we went back to the car wash and he jumped into his buggy, and I also drove back to Barcelona. Leandra phoned again on the 2nd of December 2025 and requested to come to Brakpan as he was under serious stress. He sent me a location and I followed that location to a residence place and came on foot. He jumped into my Suzuki Swift driver seat and I sat on the passenger. Leandra and myself drove around the area while talking, and the main thing was that he did not want to discuss his issues on the phone, and he preferred face-to-face talking. Hence, he always wanted me to drive to him. And on that particular time, this was during the evening. After driving around, Leandra dropped himself at the location where I picked him up, and I then drove home. On the fourth time, that is on the 5th of December 2025, Leandra phoned to meet me at Brakpan area. And I considered still driving in a black Suzuki Swift number MP36FSHP. Leandra arrived in a white Isuzu buggy where she was dropped off, and a female person that I assumed to be his wife drove that white Isuzu buggy away, and I remained with Leandra. As usual, Leandra drove my Suzuki Swift, and I sat on the passenger. We drove around the area and went to buy some food at a roadhouse along the main road. I remember fueling up my vehicle at a garage next to the roadhouse, situated on the same street, and I paid with my bank card, Captain. We stopped on the road to eat while talking from there. Leandra told me to drop him at the police station. I do not know the name of the station as I was driving. At no stage did I ever let Leandra drive my vehicle alone. At all at the time, we were together up until I dropped him at the police station. Myself and Leandra waited at the police station parking lot until he phones the wife to come pick him up, and the wife came driving in the same white Isuzu buggy that had earlier dropped him. I then took my black Suzuki Swift and went home. When I arrived at home, I saw on the news, on the news TV, that the breaking news was that Dynasty had been shot and killed. I took the picture on the TV and started to send to different people, and also received some from other people that I know, that I knew behind it. Because I must stop there because the part I wanted to read, I think it's going to stop there. And let's see. I think I must take also the phone until that was the last time I ever went to Brakpan. I tried to phone Leandra after having learned of the killing of the university, but I couldn't get hold of him. After some time, Leandra phoned me to say that he was arrested as a suspect on university matter, and that the police confiscated his firearms. Leandra also sent me a lot of voice notes that he was shot. That he was shot at, but he survived. Later on, I received news that Leandra had shot himself and also saw it on TV news. Leandra's wife that sent me a WhatsApp message using Leandra's cell phone to inform me that he killed himself. I know nothing about the state of honesty. Because I'm going to stop there. Yes, that concludes the review of the opportunity we intend to submit. That concludes the chapter.
Right, this affidavit of Detective Masuku is marked Exhibit G, coupled with Annexure A to Exhibit G.
Let's go.
And then having the state or the respondent close this case, what was agreed upon
As it pleases the court, Your Worship.
to proceed today.
Your Worship, if I may, as the only female amongst my learned
Ms.
male
Kelly.
colleagues. Your Worship, it was agreed that the matter would be postponed, should it be suitable to the Honourable Court, to next week Tuesday. We were initially under the distinct impression that it would also be for the viva voce evidence of the investigating officer. However, Your Worship, should the court deem it prudent, the court shall and has the discretion to call the investigating officer if needed. However, Your Worship, given the content of the affidavits that we have all been placed in possession of, should there be no objection from my learned colleagues, the state as well as Your Worship, we will then request that the matter be adjourned to next week Tuesday, being the 18th of August, for arguments, Your Worship, or address, rather, Your Worship, should same be suitable, Your Worship.
Okay, start with Council for the State. Mr.
At the
Sneed.
time now,
Mr. Sneed.
Worship, my instructions are to agree to a postponement to next week, Tuesday. There is a possibility that supplementary affidavits will be drafted by Advocate van Wijngaard, Mr. Nel, in respect of accused number 1, if necessary. I'm not aware to the exact merits of the bail application itself of accused number 1. As a result, they will make that call, Your Worship, and it's possible that supplementary affidavits will be adduced.
Mr. Van Os.
Thank you, Worship. I'm satisfied with the purpose and the date. Purpose of postponement and with the date, Your Worship.
Mr. Van Heerden.
Thank you, Worship. Worship, I'm also in agreement with the arrangement for the postponement of the matter till Tuesday, the 18th. And again, as Mr. Snyman has indicated, there is a possibility that the applicants may file supplementary affidavits in support of the application for their bail.
Mr. Wilkins.
Your Worship, as it pleases the court, I confirm that the date of next Tuesday has been arranged with us. We agree to that. However, Your Worship, there is one issue I'd like my learned colleague to clarify, and that is that the affidavit that they've now handed up and read into the record, I would like to know whether my learned colleague would confirm that they rely on the correctness of the affidavit and the contents they read into the record. In other words, do they rely on the exculpatory statement made by that witness? That will enable us to decide how to proceed and how to deal with our replying affidavit or our further supplementary affidavit. So, if my learned colleague would just confirm that he relies on the correctness thereof, Your Worship. Alternatively, if he does not, on what basis is this presented to the court?
I don't understand my other question.
Your Worship, maybe if I can help my learned colleague, I'll try and then explain my problem. My learned colleague read this into the record, the statement of Mr. Soteni, and in support of the application to oppose bail. So I want to know whether he relies on the correctness of this affidavit, and specifically the version that he read into the record, that he deemed appropriate to read into the record. In other words, does he confirm that the state says that is correct? If not, Your Worship, if he does not admit it, then I would like to know why it was read into and why Your Worship should accept this before Your Worship. I think it's relatively simple, as it is the court.
It's not, that's it, because now it is clear now. So now this is clear now to the attachment of the
Especially the paragraphs which read into the record.
You said that after this is from the court record. It should be from the court record. We are satisfied with that is relevant to this case. That's the question.
They must withdraw the case against them.
Your Worship, no, if I understand correctly, my learned colleague says that they rely on that, and that is correct.
That is how the court understands it.
As it pleases the court, Your Worship, I'm certain I'll receive some remuneration from that applicant because by doing that the state would concede that he's innocent of the charges. Thank you, Your Worship. Put that in the partner's method. Something you've got a conversation. Your Worship, sorry, Your Worship, just if I may raise one other issue. Your Worship, we also asked one of our clerks to just go and fetch the state's opposing affidavit in this application. Now, Your Worship will know that that is a public record. However, the clerks, for some reason or the other, refuses to hand that to our clerk. Would Your Worship just indicate and assist that we are entitled to it as it is a public record?
Yes, but the advocate in favor can assist.
Yes, Your Worship, I just know that Your Worship's word in order carries much more weight, but thank you.
Advocate in favor? Will you assist the defense to get that public documents?
I don't know when will that happen at the time.
Yes, I assume even next week.
Maybe if this is going to be done now, that means he has to make the database of the magistrate. That's what I also just asked this after the level of the court.
Yes, and I noticed that we are left with 13 minutes court time.
Yeah. Your Worship, now I just need that for our affidavit, our replying affidavit. So if we can't get it today, it's going to prejudice us in preparing our supplementary affidavit. So.
Yes, but Mr. Wilkins,
Yeah.
time is against
Yeah,
us.
no. We just need in order to be able to go and uplift it, Your Worship. We don't want to use it now. We just need in order to uplift it. Or my learned colleague might have it in his possession, Your Worship, a copy of it in his possession.
Should have.
Is the clerk of the court still there?
And they were, Your Worship, yes.
Right, the court order states, and clerk of the court, clerk of the criminal court, Brakpan, grant the defense and all advocate workers a public document as requested before this court.
As it pleases the court, Your Worship. We're indebted to Your Worship. Thank you.
Right, counsel for the state will, I call her the leading investigator, Detective Masu. Can she avail herself on Tuesday the 18th of August 2026? Right, accused persons may stand up. Matter is postponed to the 18th of August.
Your Worship. Apologies, Your Worship. I do apologize for interjecting. Your Worship, if I may just ascertain, I know that the issue was addressed yesterday with reference to the accused persons being detained at one.
They may remain seated while you are addressing us.
Whilst they remain at one of the police stations pending the finalisation of the bail application. Your Worship, I will be honest in saying that between myself and Mr. Nell, we went through extreme measures to try and see what police station would be prepared to assist us and subsequently communicate with, as Your Worship correctly noted, the lead investigating officer. Your Worship, I confirm that I telephonically engaged in a conversation with the lead investigator, Ms. Masuku, as well as my learned colleague for the DPP, regarding the aspect of the accused persons being detained at the Brakpan SAPS after consulting with the Brigadier herself. If my learned colleague for the State, Your Worship, can just give an indication as to what the outcome was, given that I did not receive any response, but obviously did not want to put unnecessary pressure on the leading investigator in this matter, Your Worship. As it pleases the Court, Your Worship.
Thank you, Worship. I was trying to whisper to my investigator, but she asked us that she addressed this providing herself for a while. Can she narrated that in the title screen? In her own words, Worship? Oh, because she was already doing that. So
You are the spokesperson. She can brief you and then you address the court.
Worship, she able to just get the decision. I've been informed that the police is trying to avoid what has been happening from the time they were detained. They have an influx of visitors, and that is now giving that commotion in the station. Therefore, and they are demanding to see everyone that comes. So it is on that regard that the station said we cannot accommodate them because of the way the people who are coming in and in droves to see them.
I hear you. Have you been answered, Ma'am Kelly?
Your Worship, I will be honest in saying that when that information was indeed conveyed yesterday during the court proceedings as well, as a means to avoid that aspect, I did inform the lead investigating officer that should the court so be satisfied, obviously after an application has been brought by the state through its instructions of the lead investigating officer, that we will adhere to the conditions of there be no visitation whatsoever, Your Worship. That will then prevent or divert from the aspect of there being a continuous amount of visitors on a daily occasion. Your Worship, I believe myself, and I speak now for myself and I believe my Galuda colleagues as well, to say that we would feel more comfortable with our clients being at, or rather detained at the SAPS as opposed to correctional services, with the exception that there be no visitation, Your Worship. It is indeed so that the matter is intended to be postponed to next week Tuesday, and ultimately so the family can then come and see the accused persons next week Tuesday.
Right.
As a piece of the court, Your Worship.
May I?
I say, Worship, that I always just now informed that the station says unless they can, as my little friend now has put, right, we put that invitation on the station. The letter is on its way to let them to be in the station, but the problem is only that. But if they cannot agree to that meeting of the distance, I don't know if the board is the case in their court.
Right. May I put this here? If anyone wants the accused persons to be kept at the police station, an arrangement should be made with the station commander. There must be something in black and white before this court so that I can order that they be kept there. In the absence of the same, this court is not going to entertain it.
Your Worship, I do concur and I understand the procedural aspect of it. Hence why I had tried to anticipate or facilitate this even before our appearance was scheduled to appear at 2 o'clock. I've just heard from my learner colleague now that in the event that everything is in order and we undertake from our side that there will be no visitation, the letter is, I don't know if it, apologies, Your Worship, I see the lead investigating officer is pointing down. I'm not sure if that means it's here, Your Worship, but if my learner colleague can just advise, Your Worship, because it is obviously a very concerning factor on our side, and I'm very desirous, Your Worship, to obtain this letter so that the court may make the relevant order and subsequent to that prohibit any form of visitation to the accused whilst detained at the SABC, Your Worship.
Some issues do not need interference by this court. There should be a gentleman agreement
As it pleases
between
the
the defense and the prosecution.
duly noted, Your Worship. As it pleases the court, Your Worship.
So, as far as this court is concerned, there is nothing which authorizes me or to make an order that they be kept at the police station.
That's what I said. That is I don't know what to do because it's just arrived to as my girlfriend was told you. May I have anything else?
No, you will have to read it into the record.
Oh, this is from the Station Commander Brakpan, date is 18th of August 2026, and it's addressed to the
Did you
magistrate.
say 18 or 13?
What should we say 18th of August? And then we should at the bottom of the signature there is 14th, the correct date.
So there's discrepancy already in that document.
There is
So now what is the purpose of reading it into the document?
Your Worship, I think you can accept that that document has been drafted today. That's why we've got it here. It's not on a later date. Your Worship, the situation and the problem as far as applicant number 2 is concerned, he informed me that they were kept at the Department of Correctional Supervisions in isolation cells where there were no electricity. They were kept in the dark, and there were a number of inmates that was walking past his cells and pointing out to him and making remarks as far as his involvement in matters where he was involved in the incarceration. And he feels extremely unsafe under the circumstances. Your Worship, the situation is, if we're going to allow specifically applicant number 2 to be returned to the Department of Correctional Services, then somebody needs to accept the responsibility as far as his safety is concerned. Your Worship, I place it on record that he does not feel safe, and he requests that he should not be detained at the Department of Correctional Supervision.
Your Worship, if I may just get clarity, it has been conveyed that there's an aspect pertaining to...
Just a moment.
Apologies, Your Worship.
I'm going to adjourn at this stage. Let the state and the defense sort out the problem and come with a solution. Court adjourns.
We are indebted, Your Worship. on the top right-hand corner of the document is actually supposed to display the date of the next court appearance. If the court is to have sight of the document, Your Worship, and you look at the bottom where the signature is, it is dated indeed for today, Your Worship. So that then conveys that they will be kept in custody at the Brakpan SAPS until the 18th of August 2026, which is the next date that has been agreed upon. That is my understanding, Your Worship, of the correspondence or communication that I had, that date on the top is almost in essence at the wrong place. But if Your Worship looks at the document, at the bottom, it is dated for today, Your Worship.
With whom?
Your Worship, if I may, without stepping on anybody's toes, I overheard a conversation, or rather the phone was put on loudspeaker by the leading investigating officer, wherein one of the investigation team went back to the police station to now get the date amended, and wherein this conversation took place to say that that date is in essence in the wrong place, and it's to convey the next date of the 18th of August, but at the bottom it displays the 14th of August, Your Worship. That can be confirmed via my learned colleague, Your Worship.
I ordered that the contents of the document should be read into the record.
Yes, Your
And
Worship.
it was apparent that there was a discrepancy.
Correct, Your Worship. I understand the only discrepancy was the date at the top right-hand corner, Your Worship, not the date that they would be kept in custody until the next court date. If my reading of the document was correct, and I stand to be corrected, Your Worship, my learned colleague will be able to provide further information on that, Your Worship.
Then the document should be read into the record.
Worship, I don't have it now anymore because they put the police took the prison. So, Worship, I don't have it anymore.
Let me rather plead with all the legal representatives, that is the defense legal representatives as well as the state legal representatives, that in future side issues should not be brought before this court. This matter could have been ventilated among yourselves. It wasn't necessary for this court to interfere and make an order pertaining to where the accused persons are going to be detained. You were supposed to bring proof before me that this is the situation. I cannot interpret that document with respect. Then, in the absence of any proof, I have to postpone this matter to the 18th of August 2026 for further bail hearing. Accused persons, that's 1 up to 6, will be kept in custody. And then the court further wants Detective Masu.
Yes, sir.
To be present on the 18th of August 2026. The court may, underline the court may, call her as a witness. I think.
Where are we being today now?
Right. I'm still going to be busy with administration on the bench. And then you are allowed to leave.
You can help with that because
Pardon?
you can help.
No, I don't need help.
I'm trying to carry favor.
The best.